warrant was issued. He has been, since picked up on the warrant, has been in custody. At this time, Mr. Cummings is still in the same situation he was on June 12th. He still has a balance of $1,255. He's made no payments to the court. He failed to complete the level 2 driver rehab program, failed to complete 100 hours of community service. He has another new pending case since June 12th, an alleged R&O, date of offense, July 22nd, 2024. He does have a PCC on August 1st in that case. So the court is also aware Mr. Cummings does have another pending case on 14B. It is a domestic violence case. He goes for sentencing on that on Monday. That is not a violation of this case. It happened prior to his sentencing. However, he also, in that case, has a bond violation as he violated the no contact order in that case. That will be addressed at their sentencing hearing as well. Mr. Cummings, in this case, Your Honor, it started as a felony case. We did get him sentenced in it. However, prior to all of that, getting him to sentencing in January, he had multiple failure to appears before this court. He continues not to follow court order. Given that he has demonstrated that he does do probation is recommending that he serves 365 days in jail, credit for 85 days that he served to date, to serve the balance, that he complete the in-jail MRT program with the court to consider early release upon his completion with that, and that he be discharged from probation without improvement with and waiving remaining terms, accepting his financial obligations.
You know, I did have a lengthy conversation with Mr. Cummings yesterday. He does admit that he messed up on probation.
Before a single word is spoken in this courtroom, understand this. This case isn't about one mistake. It's about a pattern of missed court dates, ignored orders, unpaid fines, and promises that sound good until it's time to follow through. What you're about to watch is a probation violation hearing where the judge has already run out of patience, and a defendant is about to find out that excuses don't carry the same weight as actions. This is the story of Mr. Cummings, a man already given multiple chances by the system, a man who knew exactly what the court required of him and chose not to comply.
So he admits to these violations?
Yes, except for the pending cases, for obvious reasons. Frankly, he wants to ask the judge for mercy in this situation. He would like for his probation to be reinstated. He said he is willing to comply with probation and get done what he needs to do. However, he does want to take responsibility for not doing what he needs to do over the past couple months. So when I asked him what's been going on, he kind of gave me a litany of things. He cares for his 5-year-old son, who is going to kindergarten in the fall. He also has a baby on the way. His partner to the 14th, but really the baby can come any day. Those two things, as well as his job, he's working Amazon night shift 40 hours a week, essentially distracted him from taking care of what he needs to do on this probation. He does live with his mother and his partner, as well as his children, so he does have a support system. He says he can make payments. He is working full-time, and he does have some savings that he can put a pretty substantial payment toward his fines and costs. He said his mom can come up and pay $1,000 before he even is released from jail. He mentioned to me that he has been successful on other probations, and thinks he can be successful here if the court is willing to give him another chance.
How did he get picked up on this warrant?
The police came to your apartment for an unrelated matter. And Mr. Cummings would like to make a statement. He wrote down.
Did you have something, Ms. Polera, before he?
When the police did arrive at the apartment.
Right here, the tone of this hearing is already locked in. The probation officer isn't speculating. She's laying out documented failures, missed jail reporting, 0 payments toward more than $2,000 owed, no completion of required programs, no community service. And now, on top of all that, a new pending criminal case. This is a misunderstanding or a paperwork issue. This is a defendant who, on paper, has done nothing the court asked him. What makes this especially damaging is a timeline. These obligations weren't sprung on him yesterday.
Was for an unrelated matter, and I believe that he ran, and that's where the new R&O case came from.
Go ahead.
And I want to start like this and say I do got a 4-year-old about to be 5 in October, about to start school this fall. I got a daughter due any day this month. I was working a night shift at Amazon, 40 hours a week, 10 hours and 30 minutes a day. I was laying down on my side. I didn't look at it as a punishment, but I looked at it as an opportunity to do better and be better and get my life together. I can't have warrants and actually be responsible for my son and get to school every day or even to a bus. Please don't punish me or revoke my probation. I think y'all can actually help me do and be better. I signed up for Michigan Reenters to try to get back in school and see what college is like, even though it seemed like I haven't been trying. That's something me and my probation officer spoke about. I can and I'm willing to do extra classes like MRT free and on probation. I'll pay to start my driving class before I'm even released if considered. And if you can take thought that I'm on probation for being a victim in a car accident I was in or at fault for, I went to the hospital with bad injuries, just as everybody else. Like, please, Your Honor, I've been getting dealt a bad hand. And I'll just try to be the best I can and resolve every issue the best way possible. Honestly, I'm not the best, but also not the worst. Like, please, Your Honor, I beg you, please, can I have one more chance to show y'all I actually had a bump in the road and I had to get over it, please. If you see me again, you can revoke my probation, give me a year or anything. Like, I really do and truly apologize for the confusion and decisions I left you, my probation officer to ponder with. But I really have just been working, trying to be there for my son and the mother of my child that's currently pregnant. Like, please don't punish me yet, but give me one more chance. Like, I'm actually a full-time father and my son stays with me. I can't imagine just leaving my son out the blue like this. He missed me as we speak and think I'm on vacation. I'm going to be a full-time dad to my daughter too, that's due. This is the first time you see me for a reinstatement and the last time if possible. I'd do anything to be there with my daughter's.
This is the pivot point where emotion enters a room. The defense openly admits the violations but asks for mercy, leaning hard on responsibility, fatherhood, and future intentions. And to be clear, judges do consider these things. Family obligations matter. Employment matters. Effort matters. But here's the issue. Courts don't operate on potential. They operate on proof. Notice what's missing from this request. There's no evidence of partial compliance. No receipts. No completed classes. No payments made when possible. Instead, the argument boils down to life got busy. And while that may resonate emotionally with viewers, judges hear that explanation every single day.
I was born to put my name, birth certificate. I watched my son go off and start his first day of school. Your Honor, I plead and please, I'd do anything, even if it was double my community service, double my restitution, and add extra classes. I'd do it and complete it all. If you can, please consider everything I said and give me a chance. It would be the biggest and best blessing. I know I haven't paid yet, but I thought I had time to. I had kids, house, and life things to take care of. I haven't started my driver class because I was supposed to start it a month after being released, but I didn't have a job or was told that I had to pay to start it after being released. I know I haven't started my community service, but I checked in the places that let me serve the community legally to get this out the way. If I can, please have one more chance to show y'all. You wouldn't regret it, I promise. But that's all I have to say and ask of Your Honor, sincerely.
Mr. Cummings, here's my problem. On September 13th, you were set, well, before that, I think I took your plea. You were supposed to appear for sentencing. Actually, I didn't take your plea. Looks like it was taken by another judge. But anyway, you were supposed to appear for sentencing. You were supposed to do PSI with the probation department. This was back in September 2023. And you don't do any of that. And I have to issue a bench warrant. Somehow or another, it looks like that may have gotten set aside in January. And then I adjourn your sentencing January 9th. We had to somehow or another find you from September to January. And then on January 9th of 2024, I adjourned your sentencing. It was adjourned by probation to January 24th, 2024. You show up on January.
That was an emotional plea, long, detailed, and clearly heartfelt. Mr. Cummings painted himself as a father trying to do better, a man overwhelmed by life, but not malicious. And for many viewers, this is the hardest part to watch. Because on the surface, it sounds like someone asking for one last chance. But here's the reality. Courts don't evaluate sincerity based on passion. They evaluate it based on consistency. Every promise made here has already been made before. Every commitment offered now was already ordered months ago. Judges listen for ownership, and what they're really listening for is a simple sentence most defendants avoid.
24th, and they give you a sentence. Relatively straightforward sentence. You were in custody at the time. And I laid out everything that you needed to do. That was in January. You really don't do anything on probation that I ordered you to do. So then you show up June 12th of this year on a violation of probation hearing. And at that time, and I think you were on Zoom, you were out. We told you the things that you were supposed to do or hadn't done and try to get corrected. And at that point, I kind of just sent a warning shot to you and told you, you got to do these things. And I ordered you and ordered only 10 days. And Ms. Polaris trying to work with you too. I mean, we didn't order you serve the full time. We said, here are the things you haven't done. You need to get them accomplished. So I ordered 10 days in jail, gave you a specific day to report to probation on June 24th, 2024. Did you go?
I was in warrant status. I don't think I could have.
Oh, you could have.
You're right, for sure.
And then ordered you to become compliant with all the previous terms that I ordered. So I gave you another shot from January to that June day. The 10 days, because you were on Zoom, I told you exactly what I would do. I said you're to report by 6 p.m. that day, or I was going to issue a bench warrant without bond. You must have thought I was kidding.
No, Your Honor, not at all.
This is where the hearing shifts from emotional to surgical. The judge isn't reacting. He's reconstructing history. Dates, orders, missed appearances, adjournments, warnings. This isn't anger. It's precision. Judges keep receipts. And once they start walking to the timeline like this, it means they're testing honesty against documented fact. What's especially telling is a reminder that the June hearing was a warning shot. 10 days instead of full revocation. Clear instructions. A specific reporting deadline. That was the court extending grace.
Why didn't you go?
I didn't make it by 6. I knew the deal could have been off the table. But I definitely was not thinking you was joking.
Why did you not turn yourself in then?
And I was
You
trying
want me to give you another chance,
to plead.
and you did nothing.
I could complete this probation. Promise.
What?
I can and will complete this probation, possibly, if possible.
You can't. You do what you want to do.
I'm gonna speak
When did you get picked up on this one?
about July 20th, if I'm not mistaken.
July 20th. Okay. So between June 12th, when I ordered you to report to the jail, And that day you got picked up, what were you doing to correct this?
I was trying to work, make sure I had some money, so if I had other bonds. But I do apologize, and I can't say this, Your Honor.
Here's my problem. You're apologizing because you got caught. You were, if those police had not come to your door that day, I still wouldn't be seeing you.
Yeah, I probably would have turned myself in still.
When?
That was all.
In the 45 days from the time that I ordered it to the time that you got picked up, at what point were you going to turn yourself in?
As soon as I had enough funds to take care of other cases that's holding me with no bonds and counties like tickets. And I was trying to be there for the mother of my child that's currently pregnant. I would have done my probation this whole time, but I had other warrants that stopped me from doing my probation. I'm not going to say. Yeah.
This is the most brutal moment of the hearing, and arguably the most honest. The judge isn't insulting the defendant. He's summarizing the file. 0 compliance, 0 follow-through, 0 accountability. When a judge asks for one single thing completed and there's no answer, the case effectively closes itself. Courts value honesty, even when it hurts. A defendant who admits failure stands a better chance than one who tries to explain it away. What frustrates judges most isn't noncompliance, it's denial. And here, every attempt to soften the truth only reinforces a judge's conclusion. Excuses have replaced effort.
I'm not going to say I didn't turn myself in. It was other warrants, other cases that's stopping me from being best at what I can show y'all and doing my probation.
I've given you an opportunity to show me. I'm coming up on a year, and guess what? What have you done? Nothing. Nothing. And then you're gonna, and
I
I try to give you at least a gentle nudge, and you still don't do anything. Nothing. You tell me one thing on this sentence that I gave you that you've done.
It was my first time.
Tell me one thing you did.
I checked in. It was hard. I mean, I did check in, do the non-report.
Why is it that you just can't say, Judge, I did nothing?
I did nothing.
Because I'm looking right at it. You did nothing.
You're right, Your Honor. You right.
Everything with you is an excuse.
No excuses as a man. That's what I was taught. So I don't try to make excuses, honestly.
You've made excuses since the time you first started talking. Everything that's come out of your mouth is an excuse. I sit here and I give you a chance to do it. We wait 6 months, correct something.
This is the nail in the coffin. Judges will tolerate mistakes. They will tolerate struggle. What they will not tolerate is disrespect, especially intentional disregard for court authority. Running from police while knowing you have a warrant sends one clear message to the court. You weren't planning to fix this unless you got caught. And that distinction matters. Turning yourself in shows accountability. Being arrested shows avoidance. The judge isn't speculating here. He's drawing logical conclusions from behavior. Every step taken to avoid responsibility compounds a violation.
Anybody that is on probation in my court, if, you know, and I feel bad sometimes for Miss Polera, but she doesn't mind doing it. If you're having problems, you'll walk in, you talk to her. But you wouldn't even do that. You thought this was a game. You thought when you looked me in the face on Zoom and I told you when to report that I was just kidding. Nothing that comes out of my mouth am I kidding. I told you to report. I told you when to be there. And I told you how long you'd be there. And I told you what I would do if you didn't report. And so you know there's a bench warrant out for you.
This case ends where many probation violation hearings do, not with a lack of sympathy, but with a lack of credibility. The judge didn't ignore the defendant's family, job, or future plans. He weighed them against a year-long record of inaction, missed deadlines, and direct defiance of court orders. And in the courtroom, actions always outweigh words. Probation is a privilege, not a promise. When it's treated like a suggestion instead of a mandate, the court responds accordingly. This ruling wasn't sudden. It was built step by step, warning by warning, opportunity by opportunity.